time we appeared before this court, there's obviously been some procedural changes in the case. Prior in front of Judge Scott last week, both cases were consolidated, moved into Your Honor's division. With that being said, there was an initial concern regarding some issues with conflict that I've spoken to my client about over the weekend. I am going to continue representation of Ms. Zikry at this time.
Okay.
With that being said,
You're Mr. Daniels, is that correct?
I'm sorry, no, I'm Mr. Haynes. But I
Mr.
represent-
Haynes, oh, I'm sorry,
I
Mr. Haynes.
represent Mr. Daniels.
Haynes. Okay, okay, I just want, okay, so Mr. Daniels, just so you understand, you're just gonna ride along, because your case is not set for a motion this afternoon, and we'll figure out yours momentarily. Okay, great, thank you. Now, everybody's, it's been a Monday.
I understand that, Your Honor. With that being said, we did have the evidentiary hearing on the motion to suppress scheduled today. I had spoken with the state about my intent to withdraw on Friday. We both released officers from the subpoenas. We didn't want to waste the court or law enforcement's time. Given the change of circumstance, I obviously would want to continue on that evidentiary hearing on that motion to suppress, given the court's ruling, if we were to address it today on the dismissal. But that is all we ask, that if there are any additional arguments the court would like us to submit on the motion to dismiss, I am happy to provide additional argument. But I know otherwise we were waiting on the court's reserved ruling on that.
Right, and I have watched the videos.
Yes, Judge.
So right now, just procedurally, well, hang on, I'm not done. All right, so procedurally in 25 CM 9264, which is Ms. Zikry's case, we're proceeding on defendant's amended motion to dismiss, which was filed June 28 of 26. That's what we're.
Yes, Your Honor.
Okay, all right, go ahead, sir.
Yes, so that was the state's concern too, procedurally, making sure everything was done in order. Because I know we had the motion to dismiss, the state filed traverse, the state also filed a motion to strike, and I think everything was just reserved. So just procedurally, so the record is clear, to make sure that are we denying the state's motion to strike and now looking at the motion to dismiss and the state's traverse, just trying to figure out how things are going to proceed.
Yes, that's what we're doing. Okay, so the motion to strike is, will be denied. I know the state did file a traverse.
And I responded to the
the
motion to
traverse.
strike, Your Honor, which did include some argument regarding the traverse. I'm
Okay.
happy to present additional argument to the court.
Yes, please.
Your Honor, as I cited in the motion, in order for a traverse to be legally sufficient, it actually does need to add or dispute material facts that constitute the elements of all of the alleged offenses. Just briefly, Your Honor, and relying on the written motion, in count 2, in violation of Florida Statute 84331, the following facts were not presented or included in the traverse. First, the issue of the 25 feet. There's no evidence as to whether or not Ms. Zikry was within, outside of any 25-foot requirement. There was no facts actually asserted by the state on that end. There's no facts establishing a knowing and willing violation of the warning from Ms. Zikry. The statute requires that an individual who has been given a warning by law enforcement either remain or approach within that 25 feet. As Your Honor can see in the video, Ms. Zikry retreated. Deputy Almagier continued to approach her. My client was almost back to her vehicle when she was therefore arrested. Additionally, turning to that, well, and Your Honor, there is no evidence of any intent to either impede, threaten, or harass law enforcement. As we addressed last hearing, Your Honor, Ms. Zikry was there. They were dropping off their vehicle. This is their car mechanic shop. It was on private property, a place where she had a lawful right to be. She was not there to interfere with law enforcement. She was there to ascertain what was going on with her brother. When she got there, she had seen the officer in the car behind him. The officer was in the car, which is why she was at her brother's window, asking whether something had happened to the shop, to the mechanic shop, to him. She was not sure. And then moving to the second, or to technically count 1, Your Honor, but the second part of our argument, which is the misuse of 911. Your Honor, the state has not included or disputed any material facts that establish that Ms. Zikry made that call to just make a false alarm or report. She was attempting to obtain medical attention for herself. She was not using 911 for any purpose other than public safety assistance. She was requesting medical services or using 911 to avoid a charge for service. All of this needs to be shown, including knowledge and intent to misuse the system. As the body-worn cam makes clear, Ms. Zikry was repeatedly asking for medical attention, asked once even through the back seat of Deputy Almagir's vehicle to a law enforcement officer. My client was not getting a affirmative response that medical attention was coming for her until after the call was made, and then seconds thereafter, then medical attention was indeed sought for my client, which in and of itself shows that Ms. Zikry was not in fact intending to misuse the system. And on the third charge, Your Honor, you cannot resist an unlawful arrest. And on the remaining arguments, the constitutional arguments, I would reserve argument on this time to just first address the actual traverse and the elements of each underlying offense. I can then move to the constitutional argument when the court would like.
State.
Yes, Your Honor, so this motion was filed under Florida Rules of Criminal Procedure 3.190 under C4, specifically stating that there are no material disputed facts and the undisputed facts do not establish a prima facie case of guilt against the defendant. The state has filed a traverse listing multiple disputed facts or adding additional facts or addressing misstatements of facts. And under Florida Rules of Criminal Procedure 3.90D provides that a motion to dismiss under C4 shall be denied if the state files a traverse that with details denied under oath the material facts of the alleged motion to dismiss. There are multiple facts that address first the 911 call that states that it wasn't just for emergency. In the 911 call, the state lists in the traverse that the defendant alleged on the 911 call that she was getting beat up by officers. That is not stating that there's an emergency or she needed medical attention. Also, if you see on video on the officer details as he is trying to put her in the car, that I will call 911 once I get everything in order. I will call medical once everything is in order. Also, in the traverse, the states list how when officer came into contact with Ms. Zikry, he told her to back up. Go back to your vehicle. Back up. I'm in the middle of a traffic stop. Back up. It's a law that says you have to back up. That also is a material fact that goes towards the impeding of the investigation. He's saying you're interrupting my traffic stop. As far as the resist charge, it's also denied and omitted with additional facts as to the elements of the resist that happened in this encounter, including her not following his lawful commands of backing up, and so he can finish his traffic stop. And for that, we do believe that it is a must that the court denies the motion to dismiss.
May I respond briefly, Your Honor? Okay, so first, the officer, and this is verbatim from the body cam, within seconds said, "Who are you? Get back in your vehicle." Ms. Zikry responded, she was the driver's sister, and he said, "I don't care who you are, go back to your car, I'm gonna take you to jail if you don't leave." She then began to walk away. She continued to question, "Officer, what have I done wrong?" And this is, if you would like me to segue into the constitutional issues at this point, Your Honor. Ms. Zikry is again backing up. At this point, she was not under arrest. So using subsequent facts to try to establish the resisting around without violence charge is problematic on its own. Obviously, when Ms. Zikry was being put into the car, the statement made to 911, Ms. Zikry was in an extreme state of panic. She believed she had been injured. She had the spinal injury. She had significant issues going on. But the fact of the matter is that the purpose of that call was to get medical attention. She said it as she was being taken by Deputy Almagir to the vehicle. She also ensured her compliance with Deputy Almagir because at this point the situation had escalated. Her husband had a taser scope pointed at his chest. She was hysterical and she was saying, "I will do whatever you need. Please don't shoot him." So, Your Honor, with that, on those facts, I'd rest the argument.
Okay, so first things first, let's, the state did file a superseding information, so let's take care of that housekeeping matter.
Yes, Your Honor.
So, Ms. Zikry, they filed a superseding information on July the 30th, charging you with misuse of 911 system, unlawfully impeding, threatening, or harassing a first responder, and resisting an officer without violence. As to Mr. Daniels, they filed an information charging him with resisting an officer without violence and assault on a law enforcement officer. And as I said earlier, we'll take his case separately. Okay, so I watched the video several times, and I rewound it and looked at it several times. And there was a traffic stop involved, although it was not your traffic stop, Ms. Zikry, but generally in traffic stops, I'm trying to think the right way to say this, if the actual stop is a bad stop, things that follow afterwards go away, okay? And so I watched the video several times, and the new statute, unlawfully impeding, threatening, or harassing a first responder, Florida Statute 84331, is a new law, and it's a 25-foot law. But what the deputy in this case, I heard him tell you to leave, and you then asked him, why do I have to leave? Don't believe I have to leave. And then he also told you to get in your car. But I listened to it very carefully. I never heard any 25-foot warning, not one time. And that's the problem that I have with this case, is that my understanding of the law, and I'm sure one side will correct me if I'm wrong, but that there needs to be a 25-foot warning. And then if you violate the 25-foot warning, then yes, of course, you could go to jail. But I didn't hear that 25-foot warning. And there was 3 different videos that I listened to several times and rewound and all of that. So I'm inclined to grant defendant's motion to dismiss in 25 CM 9264 as to all charges, because the first charge wasn't done properly. And I have no idea if the other 2 charges would have happened if the 25-foot warning was given. I don't know. I wasn't there. We can only speculate. But I gotta follow the statute, and I believe it requires a warning.
Requires a warning of 25 feet, Your Honor.
And, Your Honor, just for the record, at this time, the state will also object, because whether or not it's the 25 feet impeding law enforcement, is also a resist there, because if the officer is giving you a lawful command to back up and you're still not backing up, whether it's 25 feet or whether it's just a simple, a lawful command of resisting.
But was the command of you need to leave and you need to leave right now, was that lawful?
It's the state position that it was, because he's in the middle of doing a traffic stop where he's trying to handle the traffic stop, and you are coming into a traffic stop.
But he includes in that, if you listen to it, he includes the law. If you listen to what he says,
Mhm.
he says the law changed, the governor signed a new law, and you have to leave. That's not accurate. She doesn't have to leave, just make sure she's outside of the 25-foot zone.
Yes, Your Honor.
And Your
And that's the problem that I have with the case.
And
And I know
for-
it's a new law, and we're all learning how this is a little different than a resist charge, but yeah.
And just to briefly respond, given the state's objection, just for record purposes, that initial command to leave, okay, has been the center focus on similar types of law in federal district courts and in the United States Supreme Court, because there's no instruction to law enforcement of what is the illegal behavior that triggers the command to leave in order for the rest of it to be lawful. That has been found arbitrary and discriminatory under due process, that without that type of prescribed conduct to law enforcement of what should trigger that command to leave under these types of HALO laws, they have been being found unconstitutional. That specific issue itself. So for the purposes of the objection, just for the record, that is something that if necessary to explore further. However, given the court's ruling, obviously that's not the basis of the dismissal.
Right, but can you, for record purposes, could you help us out and explain how you would see a scenario working out? In other words, would the officer or the deputy then say to the defendant or?
And from my reading of the case law, because I have spent some time studying this, it starts with, there's a United States Supreme Court case, Chicago v. Morales in 1999. And in that one, that is when it's the legislature that should prescribe criminal conduct for officers to then be able to enforce. When it's asking officers to, on the beat, make situation by situation decisions without prior conduct to give notice, to give clarity to both law enforcement and the individual, that's caused issues. So in City of Morales, for example, that was, it was, law enforcement was allowed to ask people who were loitering, homeless people who were loitering, to disperse if they were illegally loitering or something to that effect. So it even had some qualifying conduct. And the United States Supreme Court said that gave the officer too much discretion to say what was loitering at that moment in time. Could he have had a bad breakfast and he didn't like how the person was standing there? And that type of arbitrary enforcement puts these type of laws in question. Well, if someone is interfering with law enforcement prior to that initial command and then is intending to remain, because that's how the statute reads.
Right, and that's
it's you
where I'm
give
going.
the command and then you can't remain or approach within 25 feet with an intent to substantially interfere, harass, what have you. So it doesn't have the same overbreadth facial First Amendment issues, say for example, than the other cases where it didn't specify you can't do this type of conduct once law enforcement asks you to leave, but it still doesn't define what is that triggering moment when law enforcement is commanded to leave.
So once that 25-foot rule, order, request, however you want to couch it, is given, then you look at the person's conduct after that warning to see whether or not they violated this new statute.
Correct, because they have to knowingly and willingly remain or approach within 25 feet of the first responder, and then additional intent element to either impede, threaten, or harass.
You can't reverse it, is what?
Correct. Yes, Your Honor.
Okay. All right, so I'll note the state's objection for the record. And based on the amended motion to dismiss, which I'm granting, I believe it's dispositive as to the other two charges after this one, so all three will be dismissed.
Thank you, Your Honor.
Right. Okay, so now on Mr. Daniels, what do you want to do? Do you want to